Well, folks, this is document 300, filed today, 10/26/2022, accompanied by document 301, where document 300 is only 13 pages. Starts off as non-party Brenda Schuler responds to motions to restrict, followed by defendants in connection with their motions for a summary judgment. Non-party Brenda Schuler, who is the one that's making the documentary convicting, by and through counsel, hereby submits the following response to the motions to restrict the defendants. Laura Cardi, Mordimos, Chrome Media, proves the defendants, documents 21, and support the defendants' motion of summary judgment. A declaration of Ms. Schuler is being filed concurrently herewith in support of her position that good cause exists for the following records to remain restricted from public access. The Schuler documents. Exhibit 26, filed as conditionally restricted by the producer defendants, transcript of the interview with plaintiff Andrew Colborn in connection with yet unreleased film project currently titled Convicting a Murderer. Exhibit 27, filed as conditionally restricted by producer defendants, transcript of interview with plaintiff Andrew Colborn in connection with the yet unreleased film project currently titled Convicting a Murderer. Exhibit 41, filed as conditionally restricted by Netflix, experts of Ms. Schuler's deposition transcript. Now, backstory of Ms. Schuler, for those of you that don't know, she's the one that helped Andrew Colborn prepare his case, also along with making the documentary. Ms. Schuler is not a party to this case, yet she appeared in a full day of deposition and producer documents. Ms. Schuler has produced over 1,500 pages of documents pursuant to a subpoena issued by Netflix. Ms. Schuler has already expended significant time and costs in cooperating with her discovery obligations. Now Ms. Schuler feels compelled to present her position on whether certain documents she produced in discovery and certain experts of her deposition testimony should be made public in connection with defendant's motion for summary. Well, sorry to tell you, Ms. Schuler, but I already read your deposition, and yeah, it's already public. Ms. Schuler is producer of the unreleased film project currently titled Convicting a Murderer. The Convicting a Murderer project is intended to serve as a follow-up to Making a Murderer series as an issue in this case. Relevant to the incident motions to restrict, Ms. Schuler produced transcripts of 2 interviews with plaintiff Andrew Colborn conducted in connection with Convicting a Murderer, and testified about the project in a deposition, for which defendants are using the support of their motions for summary judgment. While a trailer teaser for Convicting a Murderer has been publicly released, the project has not been completed and released to the public in its entirety. Further, while a few seconds of an interview with Colborn appears in the trailer teaser, the entirety of the interviews with Colborn were not part of the publicly released trailer teaser and not otherwise been made public. The production company for Convicting a Murderer, Transition Studios, has expended significant resources in producing the project. Plaintiff's response to the defendant's motion to restrict states Netflix correctly notes that Brendan Schuler's employer, Transition Studios, is represented by counsel, and indicates that it's therefore Ms. Schuler's respectfully requests that the court continue to restrict public access to Schuler documents and keep them under seal. Schuler documents qualify for restricted based on the local rules of protective order. While documents filed in court are typically considered public documents, documents can be sealed upon showing of good cause. Any motion to restrict access or seal must be supported by sufficient facts demonstrating good cause for withholding the document or material from the public record. If the documents or materials sought to be restricted, sealed, have been designated confidential by someone other than the filing party, the filing party may explain in the motion that the documents or materials are being filed under seal pursuant to the court-approved protective order and otherwise, and that their filing party supports, objects to, or takes no position on the continued sealing of documents or materials in response to the person or party that originally designated the documents and materials the confidential may, if it chooses, provide sufficient facts demonstrating good cause and to continue sealing the documents and materials, absent sufficient factual basis demonstrating good cause sufficient to seal documents and materials. The motion must be denied, and the documents and materials publicly filed by the clerk of court, unless otherwise ordered by court. General LR 79D. Every court has supervisory power over its own records and files, and access has been denied when their court files might have become a vehicle for improper purposes. To protect the confidentiality of the non-public and confidential information exchanged during discovery, the parties in this case executed a protective order, which was entered on August 19, 2021. One who produces information, documents, or other material may designate this confidential with the person in good faith beliefs they contain. Excuse me. The counsel may provide information to the court with respect to materials provided in connection with Schuler's deposition. It should be noted that the plaintiff's representation is not accurate, including the Netflix motion to restrict, does not reference Transition Studios. For sake of clarity, undersigned counsel represent Ms. Schuler only, not Transition Studios. Trade secrets are non-public, confidential, technical, commercial, financial, personal, or business information. Who produces information, documents, or material designated for the attorney's side only, when the person in good faith believes that they contain particularly sensitive trade secrets or other non-public, confidential, technical, commercial, financial, personal, or business information that requires protection beyond the afford of confidential designation. Here, Ms. Schuler designated that Schuler's documents confidential pursuant to the protective order because she believes in good faith that they contain non-public, confidential, commercial, and business information. Courts may allow parties to seal or restrict documents containing sensitive business or proprietary information. As noted above, Transition Studios has expended significant resources in producing the convicting a murder project. The two interviews with Colborn have not been made public and may or may not be included in the final version of the conviction of murder. Additionally, the experts in Ms. Schuler's deposition that are part of Schuler documents include Ms. Schuler's testimony about the conviction and murder project, including certain positions that Ms. Schuler believes final product will take. Accordingly, the interviews with Ms. Schuler's testimony about the project derive potentially economic value and remaining confidential and proprietary. The value will be lost, and other parties also interested in preparing potentially compounding works related to the same subject matter are able to obtain them. Good cause sealed with public disclosure information would eventually afford others an unearned competitive advantage, unearned because of the issue of the public disclose arises from the adventitious circumstances and of the documents have become caught up in litigation as a result, having become filed in court. Lastly, no less restrictive means existed to protect Schuler's documents. Ms. Schuler has already confined the documents she wishes to remain restricted to only a few pages of her deposition transcript and the two Colborn interviews for convicting the murder project. Ms. Schuler believes that the parties may be using other documents produced by Ms. Schuler and other experts for her deposition transcript, for which Ms. Schuler has not requested that those documents remain restricted. Further, redacted of the Schuler documents would be impractical. For example, the entirety of the Colborn interviews for convicting the murder project are confidential. Therefore, good cause exists to restrict access to the sealed Schuler documents pursuant to the local rules. So, let me stop here real quick. What I gather is that Netflix wants Colborn's interviews that she gave for convicting. I think they should give it to him. Good cause also exists in a restricted seal of Schuler's documents based on constitutional protections and applicable laws, including without limitation, Wisconsin statute, Wisconsin shield law generally recognizes the policy that the news person should not be compelled to disclose certain information, stating except for the court issued subpoena. No person having the power to issue a subpoena may issue a subpoena compelling to a news person to testify about or produce or disclose any of the following that is contained. She's not a news person, though, in my eyes. Prepared by a news person in news person's capacity to gather. This is the same fucking shit that Griesbach was trying to take. Information described 1 and 2 means following any business or organization that means print, broadcast, photographic, mechanical, electronical, or medium disseminates on a regular, consistent basis news of information to the public, including newspaper, magazine, and any other periodical, book publisher, news agency, wire service, radio, television station, network, cable, satellite network, service or carrier, audio and audiovisual production company, and parent, subsidiary, division, affiliate, or any of these businesses or organizations. Any person who has been engaged in gathering, receiving, preparing, disseminating news of information to the public for entirety, described in part, including any person supervising, assisting the person in gathering, receiving, preparing, disseminating such as news of information about the civil case, state law governs privilege regarding the claim or defense for which the state laws supplies a rule of discussion or decision. Wisconsin's constitutional law also generally recognizes the policy that the news person should not be compelled to disclose their certain information, may freely speak, write, and publish the sentiments of all subjects, being responsible for the abuse of the right, and no laws shall be passed that restrain, abridge, the liberty of speech of the press. Journalists in Wisconsin have qualified privilege based on Article 1, Section 3 of the Wisconsin Constitution not to disclose information gathered by them in the course of their journalistic endeavors. No person, however, whether a journalist or not, may be forced to respond to a subpoena in Wisconsin unless the party seeking the information encompassed by a subpoena makes a permanently showing that it justifies the institution. Application of the qualified journalist is privileged to the context of civil litigation. Requests and balances between, on the one hand, the need to insulate the journalists from under intrusion into their new gathering activities, and other hand, litigants and need of every person's evidence. The balancing is required irrespective of whether journalist information was obtained in return for promised confidentiality. Here, the publication of the Schuler documents would effectively compel Ms. Schuler as a news person to disclose the following that was obtained and prepared Ms. Schuler in her capacity to gathering, recovering, preparing news information, potentially dissemination to the public. Any news information obtained, prepared, confidence in this news person and or news information identified of any source for any news information. Further, while Ms. Schuler may not have relied on such privileges and laws to restrict the parties and their counsel access to Schuler documents in her cooperation with their discovery obligation, Ms. Schuler has not waived such privileges and laws prevented the public from the Schuler documents information contained therein. Schuler documents information contained therein to another person is disseminated to the public. News information identity of source by a news person does not constitute a waiver of the protection from the compelled disclosure. Here again, allowing the Schuler documents to publicly available would effectively compel Ms. Schuler to disclose otherwise protected information. This is retarded. Rational and further support of the fact that the parties in the council's access to the Schuler documents information contained therein are governed by a protective order, while with the public would not be in such limitations. Conclusion. Ms. Schuler respectfully requests that the court continue to restrict public access to the Schuler documents. Should the court require additional information regarding Ms. Schuler's position, she is willing and able to provide it. Should the court require oral argument on the matter, Ms. Schuler respectfully requests that her counsel be permitted to appear by video conference or telephone to reduce costs. Signed on this down and the certificate of service. Non-party Brenda Schuler's response to the motion restricted to file defendants' connection with their motion for summary judgment. Declaration of non-party Brenda Schuler's response to the motion restricted defendants in connection with the motion of summary judgment. I find it funny that Michael Griesbach's name is still on this document when he's no longer an attorney affiliated with any of this. But that's document 300 that was filed today, and there's another document 301, which is only 2 pages. Unopposed civil local rule expedited motion for leave to exceed page limits. Plaintiff, by his unsigned counsel, respectfully moves the court for leave to exceed the page limits for briefs in opposition to the motion's summary judgment pursuant to civil local rule to permit the response to defendants two respective briefs, including up to 45 pages for each or 90 pages for combined response to both motions. In support of this motion, plaintiff states as follows. Due to the factual complexity of this case, defendants sought and received leave and exceeded the page limits were ultimately granted leave to file briefs up to 45 pages each, rather than the local rule, usually a limit of 30 pages each. Plaintiff did not oppose the motion. Plaintiff intends to respond succinctly and possible to respective motions, but without leave to include additional pages, he would likely have to omit or severely accentuate discussion in important points that are necessary for him to address in response to the defendant's motions. Despite some similar themes, defendant's motions include distinct arguments as how legal principles are asserted to apply to respective defendants, distinct discussions of legal authority, and distinct treatment of additional factual material the plaintiff intends to respond. I am authorized to represent defendants. I have advised through their counsel they do not oppose this motion. Signed by April Rocksteed Baker. So, November 4th is when they're supposed to have all their discoveries put in. So, I'm sure we'll get a response before the 4th to this, and I don't know what's going to happen next. Like, it's a chess match. And November 1st, we're supposed to be hearing some news in Stephen A's case, so hopefully it's positive. But, I don't know. See y'all next time, I guess. Later.